This video is about the final order for spousal support, or also known as alimony. Once a divorce is final, you may receive or pay spousal support. In California, this is called permanent or long-term spousal support, as opposed to the temporary support which is ordered during the litigation proceedings. The permanent support order is usually a monthly payment, and it can last for many years. So you may be asking yourself, when and how is support ordered? Well, long-term spousal support is more common when you have a longer marriage or one person earns significantly more than the other. The judge can typically make three kinds of spousal support orders. One, an order of an amount of support that one spouse pays the other. Two, they can reserve the issue of spousal support. This means that the court is not ordering support now, but it could in the future. So support may be zero now, but it can change at a later date. And the third thing they can do is they can end or terminate the ability of the court to award spousal support. And that's usually with short-term marriages less than 10 years. Now, you and the other side can agree about the type of support order you want. If you reach an agreement, you can be flexible about spousal support. For example, you can agree to a buyout of spousal support in a lump sum or to a non-modifiable support order. But if you can't agree, then the judge will have to decide this issue, and the judge's decision cannot be as flexible as you have the choice in an agreement. So next you may be asking, how much and how long will spousal support last? Either you will agree or a judge will have to decide how much spousal support is and how long it will last. Typically, the longer you were married, the longer spousal support can go. Spousal support usually lasts the reasonable amount of time it would take for the supported spouse to become self-supporting. The judge starts with some basic assumptions. Under the statutes, for marriages less than 10 years, spousal support cannot go more than half the length of the marriage. For marriages more than 10 years, there is no assumption as to what's reasonable. For these long-term marriages lasting more than 10 years, support can go for as long as one spouse needs support and the other spouse can pay. This can be for many years. There are points when spousal support will automatically end. For example, spousal support can end when you and the other side agree in writing to a date that it will terminate, and the court signs off on this as an order of the court. Another way is if you're at a hearing and the court gives a termination date. The court actually orders a date it will end on its own. Another way, the other side remarries. If the supported spouse remarries, under the statute, spousal support will end. And lastly, if either spouse dies, spousal support under the statute will end when either spouse dies. However, concerning the remarriage and the death, if you and the other side reach an agreement that spousal support will survive that, it can go on longer. It just will not if it is a spousal support order ordered by the court or an agreement that doesn't have those exceptions. Also in California, there is a statute that allows for the court to consider terminating spousal support under certain conditions if the supported spouse is living with a new significant other. If that's the case, you want to consult with an attorney because that is not something that happens automatically unless it's part of an agreement in the order. For the permanent support order, the length and amount of support is based on a set of factors under Family Code Section 4320 that the court must consider. Unlike temporary support during the proceedings, there's no math formula or easy way to figure this out. Basically, the judge takes a big picture look at your situation, and they're trying to figure out based on these factors, how long would it take for the supported spouse to become self-supporting and how much money they'll need until they get there. To figure this out, the court uses the following factors. These factors include how long you were married, both sides' ages and their health, your incomes, what you're capable of earning. This is also called earning capacity. If somebody is asking for spousal support and they're not working, then the court can consider the skills and education along with the job market for those skills. They want to consider the time and cost it might take to gain the skills and education to become self-supporting. Your standard of living while you're married is also a factor the court will consider. The standard of living is basically your lifestyle. It means things like the type of house you lived in, the kind of car you owned, what kind of vacations you took and how often, and whether you use credit cards a lot. For some courts, they may look at the income during the last 3 to 5 years of marriage. For other courts, they could be very general. Were you upper middle class? Were you upper class? The courts will also look at the assets available to both sides and the debts that both sides have. They want to look at not only the income, but what's available in terms of your estate, both in assets, property, and debts. The court's also going to take a look at whether the supported spouse helped the other spouse get an education, training, career, or other professional license that built their career and the income they enjoyed during the marriage. Another factor is the need and ability to pay. What the court's going to look at is how much money the supported spouse is going to need in order to have a similar lifestyle that they had during the marriage. And they're also going to look at whether or not the supporting spouse can pay that and still keep their lifestyle at a similar lifestyle they enjoyed during the marriage. The court also needs to look at the impact of tax laws on this case and spousal support. So in 2019, the tax laws changed with regard to spousal support. Federally, orders entered after January 1st, 2019 no longer have federal income tax on them, and they're not deductible to the payor spouse. However, that can vary on your state taxes. In California, right now, they are still taxing and making deductible spousal support. They'll also look at your tax bracket, how this might impact your other assets and income. Under Family Code Section 4320, the courts are also required to consider whether or not there was a history of abuse during your marriage. And lastly, they're going to consider factors about the children. Two important ones are how caring for the children during your marriage impacted either of your careers or abilities to earn income. And they're also going to look at whether or not working now will impact your children. These factors are good things to keep in mind if you and your spouse try to agree before you go to court. Remember, going through these factors, the judge needs to consider them in order to make an order. Also, if your agreement turns into an order, you want to detail how you applied these factors so that if the court needs to examine the order later on a request to change it, the court knows what was used in these factors to come up with the original amount. If you have an issue of spousal support in your case, a great family law attorney can be extremely beneficial. If you need help with these issues, you can contact us at 949-234-8280 or visit our website at www.divorce.legal for a consultation. Remember, that website, there's no .com, it's divorce.legal. And when facing a family law crisis, having the right attorney makes the difference.